Hello, thank you for your patience. Welcome to Hot Topics in Social Media Promotions, sponsored by Venable. I'm Melissa Landau Steinman. I'm a partner here at Venable. A couple of housekeeping items before we get started. If you have any questions during the webcast, you can submit them through the Q&A widget. We'll try to answer these during the webcast, but due to the late start, that may not be possible. So if we run out of time, it will be answered later via email. We do capture all questions. So also the webcast is being streamed through your computer, so there is no dial-in number. For the best audio quality, make sure your computer speakers or headset are turned on and the volume is up so you can hear me. If by some chance your slides are behind, pushing F5 on your keyboard will refresh the page. And if you have additional technical issues, you can find some additional answers located in the help widget at the bottom of your screen. So now we can get to the good stuff. Our agenda today, moving forward to the next slide, the purpose of this, some of you will have heard me speak on sort of general topics that will come up today, like sweepstakes and contests, and loyalty programs. The purpose of today is to talk about some of the new developments in this area. We will cover some of the basics, but also, for instance, as we cover the social media platform rules that are so important here, we'll talk about some of the changes that we've seen over the past year or two, because those rules are always changing, or some of the newer types of promotions that we're seeing. So as we cover some of the basic framework early in the program, know that we'll also get to some of the newer topics as well. So let's jump in and talk about some of these interesting new topics we're seeing on social media. So in terms of the legal framework that we apply when we're analyzing, a marketing person comes to you with their great new idea for a promotion, we're always applying the same basic rules to advertising and promotions to start with when we're talking about social media as we do to any other type of promotion. Consistently, the regulators, the class action attorneys, everybody who is looking to regulate here will be looking at whether and how the false advertising laws apply at the federal and state level, the unfair and deceptive trade practices laws. You should always be asking yourself, are any factual claims that may be made in advertising on social media when you are running an influencer campaign, or that your influencers may be making and you may be implicitly adopting, that sort of thing. Are those claims truthful? Are they substantiated and backed up by reliable and competent evidence? Are you keeping that substantiation? Those are all the questions that sort of step one you should be asking. Then additionally, to the extent there are specific types of campaigns, you may need to apply the laws for those campaigns that may affect. So if you've got a sweepstakes, as we'll talk about, there are extensive laws that may apply at the federal and state level, the criminal lottery and gambling laws, the laws that require specific disclosures, that sort of thing. To the extent that you are running a telemarketing campaign, or a mobile marketing campaign, you may need to worry about the Telephone Consumer Protection Act. The FCC may be regulating there, as well as the FTC. If you are going to be emailing or even using Facebook, you may need to worry about CAN spam. So we'll be talking about some of those laws, as well as the IP laws, and how, to the extent that you are soliciting user-generated content or using third-party trademarks, you need to think about how to obtain consent, avoid infringement, that sort of thing. The trick with the social media promotion is also that you need to think about how those platform rules, how the rules of each platform may apply, because to the extent that you run a campaign that, say, violates the rules of a particular platform, of Facebook or of Twitter, you are going to risk being shut down when you're running a campaign on that platform. So to the extent, say, that you adopt some sort of automation where you are automatically having people retweet or retweeting somebody's post, you may have to worry about Twitter's automation rules. And to the extent that Twitter says, hey, these are in violation, shuts you down, you may end up with a black space where your campaign once was, and something you can't carry out to the finish. So the next consideration, to the extent that you're looking at, oh, gee, we need to make disclosures, we're running a sweepstakes or a contest, we've drafted some abbreviated rules. Where, when do we need to disclose? The FTC has some valuable guidance that talks about how do you disclose in a clear and conspicuous way, so that consumers will understand and see any disclosures that you're making. They've actually been, in addition to the .com disclosures, they've sort of been updating over the years, both in updated FAQs and then in the influencer context in particular, which we'll talk about, as to how they think that disclosure should be made on particular platforms in social media. So if you look at those .com disclosures, or if you look at where they've been talking about social media in the endorsements and testimonials rules, and how to disclose in that context, there's a lot of specific guidance about what they think is and is not effective. But to start with, as a first principle, it's important to keep what the FTC calls the 4 Ps in mind. So while there's not necessarily any kind of magic word or fixed rule about how to disclose, it doesn't have to be in a specific font or color, there aren't magic words, you always need to think about proximity. The disclosure should be close to the claim. You shouldn't necessarily be putting a disclosure way down at the bottom so that you have to scroll far down on a page to find something in tiny gray print. You need to think about where people are looking, or what the FTC calls placement. The FTC has actually done some studies. This was in the native advertising context specifically, and some workshops they held that show that consumers look at the top left on websites first. So that's sort of interesting and helps guide a little bit on where you might think about putting an effective disclosure. What is important is that the FTC has said and takes the stance that if there isn't enough space to make an effective disclosure, you shouldn't necessarily be making the claim at all. So that's sort of the fallback position there. If you say, well, we couldn't make it. Presentation is always also important. You need to label your disclosures appropriately. Just putting in a link for details isn't always enough, or a hyperlink. Sometimes, particularly with the disclosure of health and safety information or pricing, or important conditions on receiving a price, you may need to say, gee, for health and safety information, or that sort of thing. And then you don't necessarily want to make somebody run through multiple links in order to find important disclosures. So the other area where the FTC has sort of addressed is disclosures is prominence, and the idea that disclosures shouldn't be hidden. They shouldn't be at the end of blogs or tweets. They should be at the front, not buried in the midst of multiple hashtags or the like. So that's important to take account of when you're constructing your disclosures. Like I said, it's not a science. There's not specific a specific way to do it, but these are all factors to take into account. So popular on social media, something which we talk a lot about, and which are very heavily regulated, are sweepstakes, contests, and giveaways on social media. To talk about sort of our first specific example. These are very tricky, but they're so popular. We hear about them all the time, and I think probably a lot of us have signed up for them as well. But because they're regulated not only by the general unfair and deceptive trade practices and sort of false and misleading principles, but the criminal gambling laws, it's an area where you need to be very, very careful. The first step in looking at whether a specific prize promotion is legal is to evaluate whether it's an illegal lottery, because lotteries are regulated in all 50 states and at the federal level, as well as potentially a criminal offense. An illegal lottery has three elements. The first is prize, the second is chance, and the third is consideration. The first two elements are usually pretty simple to understand. Typically, you can figure out whether a prize is being given away pretty quickly. Chance, random drawing, first 100 people will win, that sort of thing. The trickier one is consideration. Some states prohibit only monetary consideration. Is a purchase or payment required? But some states also state that non-monetary consideration will be prohibited. So these are things that vary across the states in terms of how they define non-monetary consideration. A few states do prohibit requiring that you go to the store, like Michigan and Ohio. A few states will say, we're asking people to come to the store once is okay, but multiple visits is not okay, saying that you must expend substantial time or effort. So that's sort of the tough question, is what is the expenditure of substantial time or effort. Photo contests is something where there's sort of been an increasing developing practice of asking people to post a single photo may be okay. It's very simple now. Everybody has an iPhone or their Galaxy, and just snapping a photo and posting it may be okay. It hasn't really been addressed. But asking people to then give up all the rights to that photo, is that a step too far, from an intellectual property perspective? So these are the sort of trickier questions that you can get into when it comes to non-monetary consideration. And particularly on social media, where the intellectual property questions can be triggered in terms of thinking about what kinds of rights you want to intellectual property that's being posted. And we'll talk about that a little bit more in a minute. If one of the elements of a lottery is not present, then you will have potentially a legal sweepstakes, free gift if you don't have chance or consideration, and you just are giving something away to everyone. You may have a contest if you don't have chance, or you may even just you're asking people for submissions of UGC, but you're not offering a prize, some sort of request for submissions, which we'll talk about in a bit. So in terms of general requirements and what types of regulations we see as to sweepstakes and contests, many of these state laws require extensive rules that are very specific as to what kinds of disclosures are required in the rules and often in the advertising as well, things like start and end dates, who's eligible, what the odds are for sweepstakes, what the prizes you're giving away are, and their value. The Florida Game Promotion Regulation provides a list of what it considers the material disclosures that you need to include in advertising are. The list on the slide is actually what they include. But some states actually I don't think that that's a complete lineup, which is an example of some states require additional disclosures beyond what that Florida regulation requires. So that's sort of the trick, that not all the states don't always align as to what they require. And so to the extent you're running a national promotion on social media, you need to make sure that you're compliant with all 50 states. As we'll talk about in a little while, to the extent you're international, that raises some additional issues as well. In addition, some social media sites have their own rules about what they require in disclosures and releases for the social media sites in particular, so you need to be cognizant of those. Talk about those in a minute. It's generally a good idea as well to include things like liability disclaimers, publicity releases if you may want to use the likeness, name, information of the winners, a link to the privacy policy to explain how you're going to use personal information collected as part of the sweepstakes, because of course nowadays everybody wants to use, at least to some extent, personal information collected at a minimum for contacting the winners. So you need to be clear about that. In addition, a few states require registration and bonding. New York and Florida, if the total value of the prizes to be given away is over $5,000. Rhode Island, $5,000. Rhode Island for when the total value is over $500 and you're conducting through retail settings. And then a limited category of amusement gambling contests in Arizona also needs to be registered. The trick in social media promotion specifically is that on certain platforms, you of course have very limited real estate, like Twitter, for instance. And so, when you have a limited number of characters, how do you say what you want to say in terms of disclosing, describing your contest, and then also disclose no purchase necessary, must be 18 or older, and the like. And commonly you have, the practice has been to make sort of a very limited disclosure about no purchase necessary and a link to the rules, and then rely on sort of the ability to hyperlink and the sort of reality of having very limited real estate. This is different from other platforms where you do have more space. To date, that has been accepted practice, but it has not been ever expressly sort of passed upon as a thumbs up or a thumbs down in any context. So in terms of skill contests, where you've eliminated that element of chance, that, of course, then if you've eliminated chance, you can, in most states, have the other two elements of prize and consideration. The exception is that there are a few states, such as Maryland and Colorado, that prohibit a purchase or payment, even in skill contests or in a narrow category, in all but a narrow category in Arizona. The interesting question in skill contests is also, and this sort of, in general, we talked about a little bit, is there consideration, with certain activities? like posting a photo where there's very little commitment of time or effort. Some states have very narrow definitions of what consideration is, and some states have much broader definitions. In addition, with these skill contests and user-generated content promotions where you're soliciting content, you get into additional issues. You, in those rules, in addition to the types of issues and disclosures that you want in sweepstakes rules, you also need to consider what kinds of guidelines you want to include for the content that's being provided to you as part of the sweepstakes and contest, particularly if you plan to post that content live or nearly live on social media as part of the contest. Because of course now that content is going to be linked to you and your contest. So you do want to ideally have some sort of moderation of the content. You do want to include guidelines like, no obscenity. And then you want to consider things relating to intellectual property, which we'll talk about in a minute. I keep making promises here. I promise I'll follow through. In addition, winner selection becomes very important in contests. Because the important thing with saying this is a skill contest, your winners are not being selected, with using chance, is that you have to have actual skill. You need to explain to people, first and foremost, this is how we're going to be selecting our winners. This is how you need to pitch your entries. And then you actually need to explain, these are our judges. Your judges should, under sort of established case law precedent, have some expertise in the area in which they're judging. Preferably, they should be independent. And then you need to explain sort of the specific winner selection criteria and how you will balance them. There are some states, in fact, that make it clear that to the extent that there is any chance at all in how you select your winners in a skill contest, then potentially that may turn it into a chance contest. And then if that happens, then you may potentially have an illegal lottery if you've required consideration from your entrants. So this is why it becomes very important to have clear winner selection and judging guidelines. Nowadays, voting is very popular. And there's the question of whether voting is in fact, chance or skill. It has not been really clearly decided at this point under the law. But generally, the sort of best practice has become that you make sort of the voting guideline be that the public is going to vote based on, their area of expertise, which is, of course, public appeal. And in addition, the savvy sort of contest sponsor will often have two faces, judging and voting, which has the additional sort of benefit of offering a modicum of control over who ultimately is selected as the winner. Because either you can narrow the initial pot or pool of potential winners that will then be voted, or you can have voting, which will then select some of the pool that will be judged ultimately to select the winner. So the other things in considering voting is you need to think about things like voter fraud, the technical issues that can arise, Are people going to, open multiple email accounts and try to vote that way? This is something where, having a leaderboard can be problematic if then you have to eliminate a whole bunch of votes due to voter fraud. So, proceed with care. But these are considerations there. And then, you need to think about, again, privacy, intellectual property, compliance with third-party platform rules, and the endorsements and testimonials guides, which we'll talk about. So in terms of additional considerations with sweepstakes and contests, to the extent, and a free alternative method of entry, to the extent you potentially have a consideration problem, may provide a nice out there, because you can then, if people can enter for free, you no longer have consideration issues. But you do need to think about whether people, given the free AMOE, have the opportunity, an equal opportunity to enter. If somebody entering using the purchase method has unlimited opportunities to enter, then the free AMOE method also has to have unlimited entries. So that's, a problem where you need to think about how you're structuring it. Do you want to just provide, 10 entries per person, or do something like that? Are you targeting special audiences? Trade and employee promotions. There can be tax issues there. Potential work for hires issues if you're soliciting user-generated content. In particular, are you just asking people to do their job? And, do you need to think about IP concerns if part of that job is soliciting, some sort of content or submitting some sort of content? And in addition, if you're asking third parties to participate who are, say, your client's employees, do you need to get your clients to consent to their participation? So in addition, children's promotions may have special privacy concerns under the Children's Online Privacy Protection Act, and there may be simplified disclosures required. So sort of a hodgepodge there. One of the more interesting issues that has come up sort of in the news lately is this idea of discrimination for, say, women's only promotions. Last spring, one of the movie chains was running a women's only promotion for Wonder Woman screenings. And somebody challenged that as being discriminatory against men. And it was sort of laughed off there. I think the mayor of Austin actually sort of tweeted, this is ridiculous, and it didn't get a lot of attention beyond that. But the idea of ladies' nights has been around for a long time, or promotions specifically starting women. And there are some sort of human rights laws, discrimination laws, and the like that can be extended and read in some states to limit the ability to offer certain discriminatory promotions. So you do need to look closely at this sort of thing and weigh your promotion in particular to see whether it's sort of worth that. I think that there are some promotions that just would be laughed off if there ever were a challenge, but some may be taken more seriously. And this sort of is part of the mood right now, just to draw that to your attention. In terms of user-generated content generally, there are different types of programs beyond just sweepstakes. We talked about these open submission programs where there are no prize. Nowadays, there are programs that, crowdsourcing, hackathons, all sorts of programs. But one thing to consider also is just the risks inherent in asking the public for content that you do need to consider when you structure these contests. Particularly open-ended questions can be problematic from a practical standpoint. And so this is, again, where moderation can become important, and structuring your rules carefully can be important. You can get really creative entries, you get public participation, it's all a lot of fun, but you can also end up with a baseball team that's called the Pizza Rats. And I give that example in particular because one of my associates forwarded to me this week. That you may not know this, but the Yankees Staten Island farm team is going to be called the Pizza Rats for every home game this year, which I just love, actually. I think it's very sort of New York as a native New Yorker. But they held a contest to name the farm team for this year. And the results came back as the most popular results came back as things like the Bridge Trolls, the Pizza Rats, I think the Rock Pigeons. I mean, all sort of very New York things. And they're actually they sold more merchandise for the Staten Island Pizza Rats in 2 days than they did in all of 2017. So I think it actually is sort of great and ultimately a commercial success. But, you know, there are people who reacted like, what the hell? And you do need to think about that because this is by no means a unique example. And they came back with sort of a clever, narrower concept to avoid having the team be the Pizza Rats forever and ever. But this has happened before. There's a research vessel where the tug is now named Bodie McBoatface. And that's going to be an entry, I think, forevermore in user-generated content contests for naming, some, you know, variation like that. So you do need to think about these sorts of things. I've promised IP rights, and the idea of when you're asking for user-generated content, or in general, running promotions on social media, you need to think about intellectual property. Users own anything they post on social media. There is a misconception amongst some people that the platform rules that make content available to sort of anybody using social media for non-commercial uses do not make that content available for commercial uses. And so when you run these promotions and you want to reuse the content in a contest or an ad campaign, or promotions, you need to think about things like copyright and trademark and the right of publicity and all that good stuff, because you don't necessarily get ownership rights. So when you're collecting videos or pictures or images, or for that matter, when you want to name your sweepstakes or contest something, you should start by doing a knockout search. Because there's always a question of whether the music running in the background of that great video somebody submitted is, you know, owned by another company that will send you a cease and desist letter when you try to, you know, repost it on your website or use it in your next ad campaign or something like that. Or somebody just may not want their picture posted on your web page or reused in your campaign. In terms of copyright and trademark, sometimes people will say, well, it's fair use. We're only going to use a little bit. But again, there's that question of whether commercial uses are even going to have that fair use doctrine accessible. I've posted the fair use, the elements of the fair use doctrine here in the slides, which you will all have access to. I'm not going to get into an extensive discussion here, but again, it's going to be an uphill climb to argue fair use in, you know, the video that you want to use as part of your next ad campaign. So, you know, that's something I would not necessarily rely on if you want to reuse the UGC that's submitted to you again. You know, often there's a spectrum when it comes to the reuse of this IP that's submitted as UGC. that we talk about, where there's first what somebody just posts in their Twitter feed as part of a contest, then what you want to retweet, and then what you want to pick up and reuse in your next ad campaign. And so you do need to think about how you're reusing things, and sort of how also you want to obtain consent. Do you ask the person, hey, we love your tweet, respond, reply, I agree, if we can reuse it, versus do you have people actually link to a website with a release, versus do you go through much more? And so you need to be thinking about that as you structure your campaigns. The Digital Millennium Copyright Act may provide some limited safe harbors for republication of third-party user-generated content, provided that you don't touch it, edit it, that sort of thing. So those are things to think about as you think about how you're going to structure a campaign, reuse UGC. But again, this is sort of a complex analysis based on what you want to do with it. And to the extent you think you may want to edit, then that certainly won't be available. Think about also, there are certain trademarks that are particularly dangerous. Every year we have some client who says, we got the cease and desist letter from the NFL because we ran a Super Bowl sweepstakes or something like that. So to the extent that you are trying to use or reuse the Olympic trademarks, Final Four, Super Bowl, that sort of thing, stop and think if you can't use a different term, and sort of that's a red flag right there. And then in addition, to the extent that you are going to start a large promotion, particularly one that has a large prize that you're going to run for a long time, think about whether you want to register. Hashtags can be trademarks. Trademarks are trademarks. Do you want to register those if you're going to run a very important campaign? The right of publicity will protect photos and videos and other content that include or identify specific people. And so you don't want to proceed in using photos or videos or names or quotes or even social media handles without permission. That's going to apply both to the people in the UGC you submit, but also to third parties who appear in those photos and videos and the like. And so it's important to get permission, but then this can also be a big issue in images and videos provided in contests and the like, where there are third parties who haven't provided permission, or you don't know if they have. And so the question is, do you include something in the rules that says, by providing this, you are representing you have consent? Are you ready to take the risk of relying on that? Do you actually ask for those consents? Again, this can depend on a lot of factors, particularly the size of the campaign, whether you anticipate reusing, and your risk tolerance. But it's important to understand that the right of publicity belongs to everyone, even individuals, who like you and me, not just celebrities, as Facebook learned in a very expensive class action settlement when it tried to use identities a few years ago in their sponsored stories. This can also be a big issue when people try to retweet celebrity posts where they're using your product or the like. You should not just be retweeting celebrity posts without permission. So in terms of best practices, think about what you need to include in your terms and conditions. Ideally, people should accept terms. You need clear guidelines. We talked about moderating and screening entries, but ideally you do not just rely on people's representations and warranties when it comes to third parties. And you get ultimately, at least from the winner, some sort of an agreement, but even better, from the submitters, you get sort of a click wrap agreement that they agree to the terms and conditions of a sweepstakes or contest or UGC promotion. So in terms of the social media, social landscape, each platform has its own rules, and it's important to understand that if you don't follow them, they may pull your promotion down. So Facebook really has the most restrictive rules. The one that people are most likely not to get is that you can't like gated promotion. So you can't require that people like your page in order to win. But what you can do is you can require that people like a post or comment on a post and collect entries that way. You can ask people to like a post to vote. The other big thing that people don't understand is to ask people, you can't ask people to share on personal timelines to enter or for extra entries or that sort of thing. Facebook does not want sweepstakes on personal timelines. In terms of Twitter, Twitter actually recently updated its automation rules in a way that sort of carries forward their general policy of discouraging spammy activities. And that's sort of the key thing to understand in creating your Twitter promotions is they don't want you asking for retweets to win. They want you to include a limit on the number of entries per day, general limits on retweeting to entries. And so that's sort of the key thing to understand with Twitter. In addition, as a practical matter, there are certain things you should do, like making sure that people set their Twitter account to public so you can see the entries, that you have a distinctive hashtag so that you can track their entries. And then there's the FTC rules, which I'll sort of discuss en masse in a minute. In that context. Then Instagram is very similar to Facebook in that because of course Facebook owns it, both platforms require that you give a release to the platform in the rules that states that the platform is not affiliated with or a sponsor of the promotion. Instagram is unique in that you have to ask Instagram users under the terms of use for essentially Instagram users retain ownership of the rights to their photos. So you can't, you have to ask for rights to reuse the photos as part of if you want to do that. The other thing with Instagram is that because you can't include a live post, a live link to the rules, there are ways, you have to take that into account in terms of disclosures. So you can either link to the rules in the bio and state that in your content, or you have to include a link that's not live. Then besides that, you need to sort of take into account that people need to have a public profile on Instagram in order to be able to see the entries. So you want to require that. And again, you want to comply with the FTC rules, which we'll talk about in a minute. In addition, both Facebook and Instagram make it clear that you're not allowed to ask people to tag content inaccurately. So asking people to tag themselves in a photo of your product isn't kosher under those rules. Pinterest is not used as much anymore, but is still used. And Pinterest has some complicated sort of and restrictive rules in terms of you can't ask for a minimum number of pins. You can only ask for one pin. You can't ask people to vote with pins. You can't ask people to require that, or you can't require people to add pins from a selection, which was something that people were doing for a while to make sure there were no IP issues in terms of people pinning third-party IP. we have suggested that people maybe tag, the sponsor's branded items or the like, but it's still that's still sort of a complicated issue. They also don't want people to pin their contest rules, which is interesting. And then there's sort of generally don't encourage spammy behavior, like asking people to comment or the like. And then YouTube has a number of requirements in terms of linking to YouTube's community guidelines, and including a privacy policy that are very specific, and also requires that you state all disclosures that are required by the law, and state that YouTube is not a sponsor, and release YouTube from liability, which is pretty standard. In addition, they have a rule that you can't manipulate the metrics on YouTube, which essentially boils down to things like you can't use likes for voting, and that sort of thing. In addition, YouTube says that you can't ask the users to give all rights for or transfer the ownership of their entry to the sponsor. This actually generally comports with best practices now, in the sense that many of the people who are submitting content in UGC contests now are fairly sophisticated and don't really want to transfer all the rights to their entry to you as the sponsor. They'll give you a license. They'll give you a generous license, but they don't want to do what was sort of standard practice in sweepstakes or contests about 5 years ago, which was you give us all the rights to your entry. They'll give you a nice broad license, and if they're the winner, maybe they'll turn over all the rights to their entry, but as an entrant, they're not going to do that. So influencers and the FTC is of course a very big topic right now, and was in fact the topic of our last webinar. So I'm not going to spend a huge amount of time on it, but it is very hot. The FTC has spent a lot of time reminding influencers and sponsors that they must clearly disclose the receipt of any material connection or any payment or free stuff, anything, even of a relatively small value like loyalty points, and any business, employment, or family relationship to some seller or somebody that they received something of value. So I pictured the distinction here between, Heidi Klum, who received nothing. She received a letter from the FTC in April last April, as part of a series of letters that the FTC sent out to both brands and influencers who were posting on Instagram to remind them of their duties to disclose material connections. That also served as an effort to sort of elucidate the way to disclose on Instagram. Heidi here actually responded, no, I actually was just, I received that, I paid for that Dunkin' Donuts coffee. There wasn't a relationship here, so there was no need to post there. But the FTC had followed up in the fall with more letters to people who still didn't get the picture. And that was actually a very valuable campaign, in that the FTC also followed up with some guidance on what they think sort of a do's and don'ts for social media influencers. Things like you should not, you need to disclose early in your posts. You should not wait until after the, click more in an Instagram post or in other similar platforms. You shouldn't be burying your disclosure like hashtag ad or hashtag paid in a string of hashtags. It needs to be clear and conspicuous and prominent. An interesting thing was they also said that they do not at this time think that the new sort of disclosure platforms provided by the Facebook and YouTube and the like are sufficient. So that's important, since a lot of influencers and brands were hoping, I think, that would be, but they're sort of not ready to say that alone is sufficient. Some more on current best practices. There's sort of a naughty list and a nice list, as you can see, that abbreviations are not okay. Use of terms like just ambassador and employee standing alone are not okay, but something like brand ambassador or brand employee, disclosing the name of the company in conjunction, are okay. Similarly, partner alone, not okay, but brand partner is okay. Just saying thanks is not okay, but thanks with the disclosure of the fact that there was something free given is okay. That's sort of a handy takeaway for you. In social media disclosures and promotions, the FTC also, in the context of a promotion run by Cole Haan, has explained that even a sweepstakes entry or a contest entry can be sufficient incentive that needs to be disclosed. And the hashtags that you're asking people, or if you are posting in response to sort of a call to action in order to enter a sweepstakes, you do need to disclose because your pin or hashtag that's the post is an endorsement. So an acceptable hashtag or disclosure there is going to be something like hashtag company sweepstakes or hashtag contest entry, but not hashtag sweeps or an abbreviation. As you could tell from the earlier slide, similar to SPA or sponsor or SPON, the FTC does not like abbreviations. Further, the FTC has made it clear that they expect the brands and their employees to be following up. They should be trained in what to do and training their agencies, and then monitoring for compliance and enforcing any non-compliance that they see, making sure that the influencers are complying, whether it's with letters and then ultimately terminating if necessary. Surprise and delights are, to talk a little bit about sort of the latest in promotions. Surprise and delights are promotions in which free gifts are given away to consumers, but neither the free gifts nor the promotions are advertised before the gifts are distributed. So there's essentially no call to action here. There's just a giveaway. And so the question becomes, should you be making some sort of disclosures beforehand? And so we've spent a lot of time discussing with my clients about whether there is a need to pre-announce, what triggers the need to pre-announce, and to the extent that you are talking about this, saying, asking for something before people trigger the prize or the like, then, or even just running something on a very regular basis, then there may be you may be ultimately triggering some sort of legal disclosure requirements. But sort of for examples of true surprise and delights, Kleenex, for instance, ran a promotion where they went to their Facebook page and looked for people who were talking about having a cold and then sent them get well baskets. That's along the lines of a true surprise and delight. Handing out prizes to people without pre-announcement is a true surprise and delight. Even a stay tuned for without identifying what's going to happen may be a prize and delight. But to the extent that you're pre-announcing or saying, starting to talk about, gee, we will be here and giving away this, then it may be a situation where you then start to need to announce disclosures, terms and conditions, that sort of thing. The other question with surprise and delights is, do you need to have people either sign releases, either for the liability releases for use of the images and content if you take pictures of them or the like, and disclosures along the endorsements and testimonials guidelines. To the extent, the best interpretation would be that to the extent they're spontaneously posting, that may be on the line, but it's probably a best practice, particularly to the extent that you encourage them to post, to give them some guidelines about how to disclose and the like. Experiential and buzz activations are becoming increasingly popular. Things like festivals and the like that may involve giveaways and may involve often cross-platform activations that have a social component where you're encouraging people to tweet and talk about it. These often have intellectual and third-party issues where you have intellectual property and third-party issues, in particular, to the extent that you want to retweet what people are talking about, that you want to film, on third-party premises. There may be trademark and copyright issues. You may, if you're on a third-party premises, you may need to get the consent of the landlord or the owner. If you are pre-announcing this promotion, there may be crowd control and safety issues that you need to think about in advance. There may be contractor training that you need to advise people or even supply them with documents to get signed. In addition, there may be a question of how to enforce eligibility requirements such as residency or age. If you're running, say, a giveaway, and encouraging people to come to a site, then there may be a question of, gee, how are you going to make sure that people are over 18 or the like? And there may also be, for some sites, local licensing considerations. Times Square pretty extensively regulates what you can do in their environs, and the same is true of a lot of local places. There are also partnering concerns, and to the extent that you're encouraging your influencers to talk about things, then you're going to want to make sure that they're also clear on their responsibilities to disclose, say, if you are giving them something. So as an example, Marriott ran a promotion to launch their mobile app, the App Your Service, which involved, to start with, a surprise and delight, giving away free gifts throughout New York City. Red Coat concierges ran through the city, giving away free gifts and encouraging people to talk about them on social media using the hashtag #AppYourService. And then the tag was picked up, and many people started tweeting and talking about things. In addition, influencers were talking about it. And then there was an effort in terms of picking up people who tweeted locally and fulfilling requests, again, throughout New York City. There was a command center in Times Square, and so permissions were obtained for the command center. The influencers and the employees were trained in advance. And there were press efforts, but they were embargoed until the start of the promotion to avoid any sort of ruining the surprise and delight there. So you can see how there were both on-the-ground experiential and social media components to something like this. I'm running low on time, but we'll talk about an unsuccessful effort that involved both live and social media efforts, the Fire Festival that many of us have heard about, that involved an effort to set up a big music festival in the Bahamas, where people arrived having bought expensive tickets. In May 2017, they were expecting deluxe facilities and found government-issued tents and food in styrofoam boxes. Actually, the organizer, Billy McFarland, was just pled guilty to federal wire fraud charges last month. And will be serving 8 years in jail. But actually, the multiple influencers were actually sued in a class action. There were multiple class actions filed. That actually was ultimately dismissed. But it's an example. These influencers actually posted and then took them down when this disaster was announced. And none of the influencers identified that they were paid sometimes as much as $250,000 for their posts. I don't even know what they might have had for agreements or any kind of indemnification for these class action suits. So, unsuccessful festival, who knows what there was in terms of agreements. This is what, a disaster looks like. But, things may not go this bad, but certainly you do want protections for these types of operations. Charitable promotions and commercial co-ventures also heavily regulated, very popular. But one of the things, we're running short on time, so I'm going to go very fast now. They're heavily regulated. There are many contract and requirements, registration requirements in some states. But one of the things to think about in order to try to avoid some of these requirements is sometimes there's not a CCV, and there's ways to avoid structuring that, whether there's a flat donation or some of these free action efforts on social media where they say, tweet and we'll donate, or the like, may be a way to avoid all of the CCV requirements that are often so painful. So something to think about. And then often social media overlaps with mobile marketing promotions. There's a lot of compliance complexity when it comes to mobile marketing promotions, and a lack of compliance can lead to enormous potential liability. Right now, there's a class action pending against a promotional sweepstakes specifically in the Eastern District of Michigan. And there have been huge settlements, including I think the highest I've heard of was a $75 million settlement involving Capital One. You have to get express prior consent to send marketing messages via text. And when you're structuring these social media promotions, how to do that involves very complicated interactions. And so you need to think about that. And you also need to think about how to make adequate disclosures with the limited space you have available on your phones. There's also an issue of whether text messages are consideration to think about. That still, certainly premium text messages are, whether non-premium sort of standard text messages is still a bit, it's still open. So these are all considerations here. Last slide, international considerations. I mentioned it briefly, but the online promotions laws vary drastically across countries, particularly the sweepstakes laws. And influencers laws are just being addressed. Influencer promotions laws are just being addressed in many countries. But the sweepstakes laws are often very strict, can prohibit certain types of prizes, may require translations, may require registration of both sweepstakes and contests. In some countries, you may have to run a whole separate promotion if you want to run a sweepstakes. So you need to think carefully about this. And just taking the position that, oh, it's online, so we don't even have any kind of, direct physical presence in a country won't necessarily save you from compliance, under a reasonable interpretation if that country takes an interest. And there are some very large verdicts in some of these countries. Italy, there was a case against, I believe it was Samsung, for 4 million lira, which admittedly is not as much as $4 million, but it's still significant. So you need to think about a limitation in terms of countries or compliance. So it's important to do that initial review. It's important to have your rules tight, your agreements and releases, and then have your social media policies, all your policies in place. And then think about, if you're running joint promotions, who's doing what. Try to get indemnification if you can't. If you can, rather, representations and warranties about compliance at least, but know who you're working with, and then hire local counsel if you're talking about other countries. So some sort of practice tips. If you want additional, I'm here for you. But I'm going to wrap that up here, and let you get in touch if you have further questions. Thanks a lot.